The witness, Sergeant Musia, is still under cross-examination by counsel for accused 1 up to 4. However, my lord, counsel for accused 1 to 4 have filed certain submissions that, my lord, they want to amplify at this stage. There were also certain issues, my lord, that we came to see the court in chambers about. And I will then at this stage just stand down for perhaps those issues to be ventilated, my lord.
Yes.
As the court pleases, my lord. My lord, we replied to, we answered to the state submissions which they submitted them on the previous appearance. Same way also touched in the chambers, my lord. We'll just have to, we'll deal with some of the main important issues on our submissions. We stand by our submissions on paper.
The state has replied to the heads you submitted. The reply of the state came this morning to me. Shortly after they came, we were in discussion, all of us, regarding issues pertaining to this case. So I haven't gone through the heads of the state. The reply of the state regarding the submission that you are making. And it will be foolhardy of me to plunge into directing the way forward without acquainting myself with all that has been said. So I don't know if you insist that this matter should be considered first, we'll have to adjourn so that I acquaint myself with the contents of that.
My lord, we are in the hands of the court. I'm of the view that I suggest that my counsel continue with the cross-examination of the witness, and in this document we deal with it maybe after lunch.
Yeah. The other question that I have for you for clarity is whether this was circulated to all your colleagues before it came to me.
That's correct.
Okay. Like I'm saying, I wouldn't feel comfortable to address myself to the issues without going through. Actually, it wouldn't be proper, because the audi alteram partem rule will have been undermined.
Yeah, but however, my lord, the most important issue, which is our application number 1, is the issue of the media. If the court also is of the view that we deal with it after lunch, then I'll step down and my counsel continue with the cause examination.
The issue of the media has been threshed out even in our discussions in chamber. Actually, it's the reason why we are starting only now instead of 10. Like I said, I aim to address myself only to the issue of the attendance of the media. I will do so. I think I will not be able to address it to its fair capacity, but I will address myself to one matter that sticks out. In the discussions in chamber, on a general basis, we discussed the aspect of the attendance of the media in this case. This case is not being run in camera. It's being run in open court. However, for every process of this nature, there are guidelines that should be...
Sorry to interrupt, my lord. May I remain standing or may I sit?
You may sit down.
Thank you.
There are guidelines that are applicable. My understanding is that part of the determination around even guidelines happened from the magistrate's court already. When this case started, there wasn't, before me, there wasn't an issue around the media. The public, I think, has a constitutional right to know what is happening from case to case. However, in this case, the legal representative of accused number 1 to 4 have a particular issue around the attendance in court of Netflix. I don't know if Netflix has had the opportunity to see the submission given to court by the legal representatives of accused number 1 to 4, because I was told that there is a legal representative on behalf of accused of Netflix.
May I address you briefly, my lord?
Yes.
So it's Advocate Winks acting for 1010 Films.
Can you spell your name?
WINKS.
MKS.
NKS, that's correct. Now, the representatives for the accused have been referring to the attendance of Netflix, but Netflix is not in attendance. I act for a company called 1010 Films, which is a South African production company, which does have an agreement with Netflix to produce a documentary. But Netflix itself is not present in court and has no direct stake in these proceedings. So 1010 Films submitted an application for permission to film on the prescribed form, and that application was granted, I believe, on the 5th of April this year by my lord. In answer to your question, we have not seen any submissions on behalf of any either accused or the state in relation to 1010 Films' right to record the proceedings.
Thank you. There we are. I do want to make a ruling before we proceed. But I think, again, it has so happened that a document is with me which affects some entity that was not appraised of the document being given to court. And this is pushing me, if I were to go along, to make a ruling without listening to those people. And like I said, one of the natural rules of justice is to listen to both sides before I can make a ruling or even a judgment. Because I would have thought, if it is about them, by the time it hits my table, they will have been favored with a copy. And this is something I should comment about, that on a repeated basis I'm receiving documents which affect people who have not been contacted about. The other time we had a document which had a bearing on this case, which one of the legal representatives claimed not to have seen. And this makes for difficulty on my part. So on this one, I cannot proceed and make a ruling if indeed they have not been favored with a copy, because in this document you want them out of this courtroom. You want Netflix, and by implication their legal representative as well, out of this courtroom. And how do I make such a ruling if I haven't listened to them?
My Lordship, for correction, is 10 films.
Yes.
We had discussion with your Lordship in the chambers.
Yes.
With regard to this issue.
Yes.
And furthermore, on Friday, when we were in Hillbrook Court, they approached me and they phoned me. I gave them my email address to send me email. They didn't send me email. However, because they're not part of these proceedings. They are not part of these proceedings. If the court wants to hear them, I'll provide them with a copy. My concern is that the way it was handled in the chambers, now it comes out different, Your Lordship. But if the court insists that...
In chambers, I didn't know that they were not favored.
Thank you, yes.
I presumed that in the normal course of events, as you give me this document, you will have favored them with a copy. That's why I was even ready to listen to them and then make a ruling.
I waited for them to send me email, but I'll provide them with a copy, Your Lordship, right now.
And how do I make a ruling without listening to them? Because it means that they have to have sight of that document and also address me, because whichever way it goes, I will order that they stay in or they go out.
Your Lordship, if the court can remember, in the chambers, when we handled this matter, the court informed us that they will decide on the matter in court. So at that moment, we stopped it there. However,
Yes.
I don't want to waste the court's time. We can stand the matter down. I provide them with a copy.
When I said I will decide, I will rule in court, I assumed that I will listen to them, and after they address me, I will make a ruling. Now, unbeknown to me, they hadn't had sight of the document on the basis of which they may be ordered out. That's why I'm saying we should then give leeway for them to have sight of the document, and then on that basis they will address me. And still on the issue of the media, I can say now that in chambers we reflected on how things are happening within this courtroom. Even the clips that are being taken and the footages, it seems like a free for all in terms of where the cameras beam. Some of the representatives were even complaining that even when they want to consult their clients, the cameras follow them, and that tends to be invasive. I think we have to do it in a manner proper. Usually what I'm used to is that when there's a witness on the stand and there are no issues, it's not a Mr. X or Miss X, the cameras beam. I also see that the state prosecutor and the representatives, the cameras beam. But here I think the cameras are picking everyone, and it doesn't seem to be in line with what we are used to. But in any case, we'll address that when we come back. On that vein, I think, did you want to say something?
Yes, apologies, my lord, if I may beg an indulgence. I've just had sight of the one-page submission from my learned friends. I am prepared to argue along the law if the court so directs. But might I make a brief submission, which is this, that the proper order of litigation when it comes to these matters that I respectfully submit my learned friends should have followed is that on the 5th of April, a right vested because my lord granted permission for my client to record, like all of the other media. There is now an application made in the form of a not under oath, not an application on notice of motion supported by a founding affidavit under Rule 6, but kind of a document that is sent not on evidence, where constitutional rights that are vested are sought to be wrenched away from my client. Now, as a matter of law, it, with respect, cannot be the case that an application is brought, especially when constitutional rights are sought to be limited, without evidence, as was held in one of the first broadcast cases, MIDI TV, in the Supreme Court of Appeal. Rights, including the right to open justice, can't be limited on the basis of mere speculation or conjecture. It has to be based on evidence. And obviously, my client has a right to be known what it's accused of, to know why it is being singled out among all the other media companies to be excluded. Everyone else in the country could walk through the court's doors and see what is happening, but my client is being singled out for exclusion from the proceedings, and that has to be based on evidence, not merely on conjecture. So what we would respectfully submit is that while we're prepared to argue the law, and we believe that a case hasn't been made out in the document that's been sent to you, that the proper order of things, especially if it were to form part of an appeal record, is that an application has to be brought on motion with a supporting affidavit providing evidence as to why my client's constitutional rights have to be limited. Thank you, my lord.
Before you sit down, if I were to shed light, I hear what you are saying about the manner in which this, shall I call it, request, as you are saying, it doesn't fulfill the requirements of an application. The one disconcerting issue is what is being done, or what the information gathered by the entity you are collaborating with is being used. For example, I was told this morning that just a few days, that entity flighted I don't know whether it's a film or a documentary, and according to that, that thing that was flighted, it sends viewers to make a judgment call on role players in this case, the bench, the state, and the defense, and the witnesses, and other people who might not be involved in this trial. That is the concern. And the concern is, the other concern is that you represent an entity which is not a media house, and I would be interested for you to respond to that. That which is not a media house, which is here as a business concern to gather material that it intends to use within the concourse of its business venture. And therefore, when permission was granted for the media to be in attendance in this trial, it did not include business ventures that want to do the one or the other in pursuance of the objective of their business.
Shall I address you?
Yes.
So, well, firstly, all of the mainstream media who are attending these proceedings and who record all criminal proceedings or civil proceedings in the country are business ventures. There is no non-profit company present in court today. The SABC, ENCA, Newsroom Africa, these are all business ventures that derive revenue, otherwise they wouldn't be here. They wouldn't be sustainable. So we don't understand why one is being singled out and not the others. The other issue is that documentary makers are members of the media. It's implicit in a range of higher authority that documentary makers, in fact the MIDI TV case was about a documentary maker who had aired in advance of a trial an interview with someone who had spoken to an accused. And the Supreme Court of Appeal found that this was a perfectly permissible way for that media company, despite being a profit company, to exercise its right to open justice, to report on matters of public interest. Now, even in the Oscar Pistorius matter, where Judge Precedent in Lambo ruled that the media could attend, one of the applicants was not a so-called mainstream media or 24-hour news channel, it was Carte Blanche, which is a documentary maker. And what Judge
in that case, was anything flighted publicly which suggested who is guilty of what before the trial was concluded?
Before I answer that question, I have to say that it's the first time we're hearing this accusation that we're now called upon to answer by the representatives of the accused, that we've somehow pronounced anybody guilty or innocent, or that there's any interference with the administration of justice. If there's been an administration of justice, and this is what the Supreme Court of Appeal and the Constitutional Court have repeatedly held, then you report it to the police. If there's contempt of court or anything like that, you report it to the police. But that speculation is no basis to exclude the public from their right to know, and to exclude agents of the media from gathering the information to be able to enable the public to know. Now, we have no idea what we're being accused of, and certainly we reject having done anything illegal. My client has not done anything illegal, and if they have, then why have they not been reported to the police? Now, if it is alleged that our client has breached in any way the guidelines of the court, then certainly that could be brought to my Lord's attention. But we don't understand there to be any allegation that there's been a breach of the court's guidelines, the practice manual guidelines, concerning the filming and broadcasting of court proceedings. Now, the other issue is that, yes, there was a five-episode documentary broadcast before this phase of these proceedings commenced. There were also news inserts on every major news channel in the country. There would also have been a documentary by Carte Blanche about the proceedings before they commenced. There's absolutely nothing unusual about it. And in the Oscar Pistorius case, and it was one of the objections raised by Mr. Roof or Mr. Pistorius, was that these media companies have been, they already have a 24-hour news channel where they have analysts talking about the case. But there's nothing wrong with that. There's nothing wrong with the public having a platform to form an opinion about pending criminal proceedings even. If it's not a sexual offense, or
and doesn't it have potential to straitjacket a witness, the one witness or the other who is still to participate in this as a witness in this trial?
That's precisely the speculation that was raised by Mr. Pistorius and was rejected by Judge Precedent in Lambo. was that witnesses take an oath to tell the truth. Now, witnesses could have many reasons to lie or to manipulate their testimony. The fact that the proceedings are going to be broadcast or live tweeted by a journalist the day before that witness gets into the box means that they get a preview of what's being said. That simply, in the 2020s, can't be avoided. They're going to know what the other witnesses are saying. There's nothing that, there's no additional risk that is posed by a documentary maker. And for the record, all of the other news agencies here flight documentaries.
Are you even suggesting that before we conclude this trial, you will consider yourselves to be at liberty to flight another documentary before a verdict in this trial?
There's no legal prohibition on it as long as the administration of justice is not brought into harm's way. And there's no, we're not under any understanding that that's being alleged, that the administration of justice is being brought into ruin. And if that's the case, if the administration of justice has been obstructed, then the appropriate place to deal with that is what has already been flighted. Now, there's nothing to prevent Newsroom Africa or SABC or ENCA from having a group of analysts discuss a case. They can get a criminal law expert from UCT to come and talk about the case tomorrow, the next day, next week, next month, before the verdict is given, and those legal experts can give their views. It happens every day that in pending and underway criminal proceedings, the news media interview experts to talk about the case and to give their views. There's absolutely nothing unusual about it, and there's nothing illegal about it, and there's nothing that poses a risk to the administration of justice. What the accused have to do is to satisfy the court on affidavit that they cannot be guaranteed a fair trial by your lordship if this particular targeted, singled out media company is allowed to do what all of the other media companies are allowed to do. That's what the threshold they have to set, is that they can't get a fair trial if the proceedings, well, in fact, it would be a bit of a brutum fulminus because there's nothing to prevent anybody else from analyzing and discussing the case. So what they would have to see, and it would be an extraordinarily high threshold to see, is that all of the media have to be included. There can't be any basis to single out one. All of the media would have to be included if it is their case that they cannot be guaranteed a fair trial by your lordship. If any recording, contemporaneous broadcast, live broadcast, or even after the fact broadcast and analysis is to be conducted by any of the media companies present, there would have to be a gagging order on everybody until the end of the trial at least, if that is their case.
Two quick issues. The one is that permission was granted for media houses to do what they are doing. And the one pointed allegation that was brought my way in chambers is that you are not a media house. If permission was granted for the media houses to do what they are doing, it wouldn't include you. You would have to seek permission for yourselves to also do what you do, which endeavor would be subjected to the same consideration as was done for purposes of the media houses. I think that is the pointed issue that was brought my way. And the second that was raised in chambers is that the approach that you take in any way tends to, shall I say, I'm using this word very loosely, tends to intimidate potential witnesses who still have to participate in this case. I grant that in as far as that is concerned, I think the state and those witnesses do still have certain latitudes at their disposal to be able to address their plight. But that's what was brought to me, the two issues that were brought to me in chambers.
Thank you, my lord. And as my lord knows, I am hearing these allegations for the first time because I was excluded from the chamber's discussion at Mr. Teko's request. The second allegation I'll address first, which is that somehow we're intimidating witnesses. Again, that obviously could be brought to the police's attention if it were true. But,
sorry, I didn't give a complete thing of it. Not only intimidating, that you are even accessing them before they testify, and you are having them entertain issues which form part and parcel of what they are going to testify about.
Well, my lord, we have to see those allegations on affidavit, and my instructions are that my clients have certainly not done anything improper. We would reject the allegations that we've interfered with witnesses in any way. And it's my instructions that everything in the documentary is also elsewhere in the public domain. City Press has conducted the same interviews with witnesses. Witnesses have given interviews to a range of media houses. And it was precisely that issue in the MIDI TV case that the Supreme Court of Appeal said it would be acceptable to interview a witness or a potential witness in an upcoming criminal case. This is perfectly acceptable for the media to do that. Again, that was a documentary maker, which leads me to the first question my lord has just posed, which is whether my client is a media company. Of course it is. Documentary makers are media companies. There is ample authority for that proposition. The right to freedom of expression guaranteed in Section 16 of the Constitution is not limited to people carrying a certain identity card. In fact, licensing of journalists is prohibited under international law. You can't require people, in order to exercise their rights to free press in the age of citizen journalism, to have some kind of special status as a big media house like the SABC. Moreover, my client is not relying on the general permission that was granted to other media houses, not at all. My client directly submitted a request to your lordship's office through your registrar. I have a copy of it in front of me.
Yeah, even as you do that, I can assure you that the registrar that you are about to refer to will tell you that she thought, without reflecting, without knowing differently, she thought and assumed that you are a media house. That's why I'm raising it.
And that assumption is perfectly correct, because we are a media house. And the application makes it very clear what 1010 Films is. There is no reason to distinguish or discriminate between 1010 Films and any of the other media houses that are present here. There's absolutely no reason whatsoever. And if in fact it is going to be the case of the accused that this permission was granted in error owing to an oversight on the part of the registrar, if that is to be their case, they have to bring an application under Rule 42 for the rescission of your lordship's ruling, because the permission was granted and the rights vested. They now want to wrench those rights away. They have to bring an application to rescind my lord's order. If there are no further questions, my lord, I'll take
No, thank you also for saving us time. But we didn't have to adjourn for you to address. There you are.
Yes, please, the court, your lordship. Firstly, Advocate Wings. The Wings. Yes. It's misleading this honorable court, your lordship. As per our discussion in the honorable chambers, I've made it clear that there's a difference between the media house and the production house. These people are the film production. They are not a media house. They are not a mainstream media when you talk about 405, 403, 417. So these are the people they are here not for the public knowledge or information. They are here for the profit of their company.
As you address, I'm not interjecting. He says everyone else is here for the money.
Yes,
Among others.
I heard that.
He says there's no one here who is not about money.
I heard about that, Lordship. So the response to that is that it's also being disingenuous. When you talk about SAPC, okay, for example, because there is already permission, you talk about 404, is the SAPC. You talk about 403, 405. These are the mainstream media house, and they are regulated under BCCSA. If there is anything that is done wrong by those media houses that I've mentioned, we know where to go and report them. We cannot go to the police station to report that the SAPC has done 1, 2, 3. That is a madness. What will the police do with the wrong that we feel the right of our client has been infringed? Can we go to Hartsfontein police station or wherever? That will prove a madness to the part of the reporter. So he has been disingenuous. So for him to say we must go to police station, can we go to police station and report that the Netflix, as it was fitted by the 1010 film production, that documentary to flight it 4 days before the real court starts, then our witnesses, I've mentioned it, Your Lordship. I said somebody requested me to watch this. Said it's got a 5 episode, this documentary. I don't want to watch it, but ultimately I was convinced to watch it. Why? It was because after my client, my potential witnesses of the accused 1 to 4, they complained that we have been exposed to the harassment, to the intimidation. It's a common cause that this court knows that we have been harassed. Starting with me as a counsel of 1 to 4, my attorney, and all those interested parties in our case for accused 1 to 4. We got intimidation, we got the threats. We are not saying Netflix or the 1010 film production intimidating our witness. He said they are exposing our witness to intimidation, to serious threats to their lives. So where is he coming from? Say that if his company, his client is intimidating our witnesses, we must go to police station. That is a madness. So what we simply and shortly say, 1010 film is a production. It's not a media house. It's a production house for the films. They are for money. Yes, SAPS and all this media mainstream, these are the mainstream that can fit his client. If 1010 production, they want to make a film, in particular, in regard to this trial, proceedings here, media mainstream has been allowed permission to be part of the proceedings here. He knows very well.
And he's saying
that
he too, his client too was given permission, and if that permission was given in error, then
we have to rescind it.
Whoever wants it to do away with it must go the way of rescission.
It's a very disingenuous submission from my learned friend here. The 1010 film production came with a back door. They took advantage. Whenever I came they just came in. You see, there was a floodgate open. I don't want to blame the court, but they just took advantage. So it's not court that we don't even know. And then the court, with the due respect, court cannot today or him demanding us that we must bring the application, the proper or whatever, because he already critiqued our submission here. Said, bring the application. Why should we bring the application for people who didn't bring the proper application themselves? Are they saying because we are already in, you are now one leg backward? No, it cannot be. So we were never part of that granting of the application, if there was ever application. But I can sense there was never a proper application that they brought. They just came in when the mainstream media came in, because we know, and he further goes to say, his cited authority is the Oscar Pistorius issue. In the Oscar Pistorius issue, in the history of this country, in the jurisprudence, in the history of our jurisprudence in this country, it was never happened whereby the film will flight the documentary before the main court starts. What happened with this? It's a first time. And as I said, Your Lordship, in the chambers, I spoke this with Advocate Wanoyi, because knowing that Advocate Wanoyi is the dominant litis in this, I say, you must know, I'm told that 4 days before we start at the High Court, the real court where there's a judge, not the judge of the public of the Court of Public Opinion, there will be this film that will be flighted and talking about our cases, the cases that is coming, the pending case in the trial. And in that trial, I also highlighted to him that my witnesses have been exposed to all sorts of threats. So he cannot now say that this thing is quite different. Oscar Pistorius' matter is not the relevant authority that he can give to this court. They've merged their own thing, and they must be the architect of their own fall. That is my okay before Your Lordship. And they are saying that the reason they should be allowed to be here because they want to inform the public. Which public? Because if you don't have money, you don't have a DSTV or whatever. My grandmother, that day in Hamashashani, cannot see the Netflix. Unless you've got the money. She's got the money. She's a pensioner. She cannot afford that. So it's not true. It's a disingenuous again to say it's for the public consumption.
Isn't it about money for everyone? Don't you have to have money to buy a radio, a newspaper? It's about money.
You mean my grandmother?
Yes. Otherwise, where does she get it? She gets it from the radio. She gets it from Sowetan. It's all about the name is not Netflix, but money all the way.
Yeah, but for these people to get money, they must go to Netflix. And Netflix is for the middle what are these kind of rich people? Middle what? This category.
You know, Advocate, you've made me to be very sensitive, because with terminology, I want to be careful with you. You want to say middle? Can I risk and say? Do you want to say middle class?
Middle class. So I'm not born from the middle class. My grandmother is so poor, cannot even afford to buy white bread after 15 days after the pension. So she cannot afford. These are the people for the middle class, not the poor people there. And secondly, for the information of this court, if they are saying that they are interested in the proceeding in this trial, in particular, in the case of Procedure and 4, whereby there's our clients. On the 27th, which was Friday, I'm accused at the Improper court. They were there. It seems as if they are following me. I asked them, guys, what do you want here? This is my court. It's not the Senzo Meyiwa issue. Are you stalking me? Or what are you doing? So I couldn't explain. No, we have applied. Who did you give your application? No, the judge has granted us. I said, no, that court there in Pretoria is not for the judge. It's for the accused and the state. So we never saw your application. Then you must know, if you've got your apparatus there, I'm told that you've got the sophisticated films and cameras. If they are there, start in Pretoria High Court, just go and take them. We don't want to find them on Monday. Or if you bring them on Monday, don't bring them. Save that, save your energy, bringing them. But here they are. And as I'm speaking now, he's busy with me. Which is unfair. So, Bishop, then you can say that it's not about informing the public. the information for the public is a 403, it's a 404, it's a 405, it's a 702, it's a, all the media, basically, that we know, everybody knows. So, with the due respect, it's our humble request, Your Lordship, that if they need us to engage them, because now they came with the back door and we're wasting our time here. Here is a poor witness who still understand, I need to finish with this witness today. But now we're entertaining something that does not have a jurisdiction to be entertained. So if they need us to bring a proper application, because they didn't bring the proper application, we will do that outside this court. And there are those people who are the relatives of our clients. What is so heart-rendering, Your Lordship, is that this is not only impacting on our witnesses now, it's also impacting on the family of the bereaved. Because they are doing the so-called Insusutu, the Hulawalam pillage. They are benefiting at the expense of the deceased here. This is very painful. And there's also some racial connotation that I cannot mention on this platform. Just know they are there. If they need us to litigate with them, this is not the right place. We will make our applications outside because they are even owing our clients. Our clients needed too much money from these people because they benefited, they profited from the Netflix when they sell their documentary. Even now, it cannot be that these people should be given a leeway to film this free of charge without buying. Because now, as they are busy now, they are busy for the 6th episode. Now that 6th episode, they themselves, they have a material where they have never spent. So previously, with this 5 episode, 1 to 5, they had a role player, whereby some of our witnesses to be were interviewed in that documentary. Because as I said, I watched the ones and all 5 episodes because I was forced because of the cry, the complaint of our witnesses in this matter. If it was not that reason, I wouldn't bother to watch their Netflix, despite the fact that I can access it, but I was not of that interest to watch it. Because it won't benefit me, because I cannot watch a superfluous something that I know that I'm going to come in the real court, facing the real justice, facing the real witnesses. So, in conclusion, Your Lordship, before my team finish what is so, this is our submission, Your Lordship, that we say we are amenable to fight or to engage them in a court of law. But that court of law, motion court, as they will be bringing their application, it should be the motion court. It should be another court, not this court. They are in the wrong court here. Here we are dealing with the criminal proceedings here. We were supposed to have been started with this matter a long time ago. So now we are saying we are amenable to bring application, or they themselves, they can bring application because it's them who want to be part of this proceedings. Let them bring the application in another court. We will attend to them. We are not afraid of them. We will deal with them. And they won't succeed. They will never be here. So today they must just get out of here. Take their properties, apparatus. I see them with the beautiful cameras. But let them take it out. We want to start. Mr. Musia is tired. He's been long sitting there. That's my submission, Your Lordship. Thank you.
Advocate Inshallah.
No response, my lord.
Advocate Baloy?
My Lord, in the response that we have filed yesterday evening, we have dealt with the issue of the media coverage, and we have referred to the locus clausicus on media coverage, and this is the case of the NDPP, this is Media 24 and others. It's a decision that was given by the Supreme Court of Appeal on the 21st June 2017, and it really lays down the law as far as the coverage of the criminal proceedings are concerned, or court proceedings. And the purpose of such coverage was aptly set out by the Supreme Court of Appeal, and they are the following. The court mentioned that it is important to emphasize that whilst greater access by the public to the court system by means of televised proceedings will result firstly in demystification of the judicial process. This is the first purpose. Second purpose, greater informed deliberation and critical assessment of the judiciary based on the public's ability to readily observe judicial proceedings. Thirdly, increased understanding of and respect for the judiciary based on the public, increased ability to observe the daily workings of the court. And fourthly, improve journalistic standards relative to court reporting resulting from greater coverage of court proceedings, and the development of court reporters specializing in judicial matters. And lastly, heightened public awareness of deep-seated social problems. In other words, the Supreme Court of Appeal is saying that the coverage of proceedings has got this important function of informing the public about, the workings of the court in order to demystify, court processes. And furthermore, my Lord, the court went on to say that a judge may terminate coverage at any time upon a finding that the rules imposed by the judge have been violated, or that substantial rights of individual participants or the rights to a fair trial will be prejudiced by such coverage. It is allowed to continue. And this, my Lord, relates to the submission by Mr. Weeks that the rights are vested when permission was granted on the 5th of April, and therefore it cannot be taken away. We submit, my Lord, that that is not correct. The court can at any time, if it feels that the permission that has been granted is being abused, it can terminate such permission. And my Lord, we submit with the greatest of respect that on its own admission, my Lord, Media 1010 flighted a documentary a few days before the trial started. There is an old sub judice rule, my Lord, that once proceedings are pending before a court, that parties or comment on those, there should be no comment on those proceedings, which comment seeks to influence the the presiding officer or the outcome of such a case. We've heard, my lord, that when this documentary was flighted, there were interviews with witnesses. The witnesses were, or the public was invited to proffer comment as to whether anyone can be held liable for killing Mr. Senzo Meyiwa. That is what this court insisted. In so doing, my lord, this media 1010 usurped the function of the court. Now, one has to ask oneself, if they saw it fit to flight this documentary, and the impression that was created is like, they have the whole docket. If they saw it fit to flight this documentary a few days before the trial started, what are they still doing in court? What do they want to have it both ways? They flighted the documentary before the proceedings started. Now they also want to take part in the coverage of the proceedings. And my lord, there have been instances where we've been informed that discussions between counsel has been heard on television.
If I may interject, yes. and sorry to do that,
yes.
Because my response to that, I want you to then cover this as you go on. My response would be that for something that has already happened, I wouldn't think that we need an order now for them to vacate. There's nothing to prevent anymore because it has happened. But then I asked a specific question to Mr. Winks. I asked him if he is implying that there is a possibility that before the conclusion of this trial, there may be another documentary, and his answer was that there is nothing preventing them from doing that, which I found a bit worrisome, because like you are saying, we are running a trial, and somebody is saying that they are free to flight a documentary that even hinges on the guilt or otherwise of individuals before the trial concludes. I found that particularly worrisome.
Yes, indeed, my lord. They have shown, as we've already indicated, that they don't really pay much attention to the sub judice rule, and they've also indicated, my lord, in court that the possibility of them fighting another documentary cannot be excluded. And if one looks at the whole purpose of media coverage, it's basically for news channels, for news channels to inform the public. And the submission has been made that they are not a news channel. They might be a media house, but they are not a news channel. My lord, we beg the submission in our heads that in terms of section 173 of the Constitution, this court is empowered to make its own rules as far as, or to lay down certain guidelines as far as the coverage of the proceedings is concerned. And the SCA did say in so much in the case that we just referred to, and the SCA expressed itself in the following terms, The power recognized in Section 173 is a key tool for courts to ensure their own independence and impartiality. It recognizes that courts have the inherent power to regulate and protect their own process, and the court further said that it remains the duty of the trial court to examine with care each application. That court should exercise a proper discretion in such cases by balancing the degree of risk involved in allowing the cameras into the courtroom against the degree of risk that a fair trial might not ensue. And the court also referred to the case that my learned friend has referred to of the media television, where it said prejudice must be real and demonstrable. My Lord has already indicated that, you know, in the documentary, the witnesses were referred to, they had to give a version of what happened, and viewers were also invited to express an opinion on the merits of the case. We therefore submit, my Lord, that based on the previous conduct of Media 1010 and what they have submitted in court today, that the possibility cannot be excluded of flighting further documentaries, that they should, we agree with the submission of counsel for accused number 124, that they should be barred from further participation in the proceedings.
My Lord, may I beg a further indulgence to respond? It's become very clear from the submissions of both my learned friends that what is being sought from my Lord is not, in fact, a protective order, but a punitive one. What they're seeking is to punish my client for what they said my client has done.
But your client doesn't rule out a possibility that what is being complained about.
This is precisely, apologies my Lord for interrupting you, that's precisely the factual submission that I'm now rising to give, which is what I did before was give a legal submission because I'm counsel and not a witness, and I'm not as comfortable giving evidence from the bar as Mr. Tepo is. 90% of his submissions, I think, are giving evidence from the bar, which is precisely the problem with this case, because they should have brought an application on affidavit. Now, my instruction is that there is no intention to flight a documentary before the end of the trial. What I had submitted is that there's no legal prohibition. And
Yeah, because that's left me very worried. I mean, you looked me in the eyes and said there is nothing that prevents them from
because I
saying
didn't have an instruction on it, my Lord, and legally there is nothing that prevents them from doing so. There is the sub judice rule. We're being accused of having breached it. For the first time now, we're being accused of having breached it.
But that would be intrusive against the process.
We haven't been given an opportunity to answer that case, that we have criminally breached the sub judice rule and ought to be punished by being sent out like a dog. We've heard it for the first time right in front of everybody else that we have committed this criminal act and we have to be kicked out. And this is precisely the problem with the way that this application has been brought.
What would be
after Van Breda, the courts and the judges president and the office of the Chief Justice decided that this is a form, an application form, that any media company can submit if they want to record proceedings. Despite my learned friend Mr. Tepo accusing me of having lied to my lordship, I have not lied to my lordship. That application was completed by 1010 Films. They said, we are making a documentary. We are not one of the pool arrangement media houses. We're making a documentary. We want permission to record. We completed the application.
Was that when the case was in the High Court, or was it when
that
it
was in April. That was last month. And the application was granted by my lordship. So that then puts, and because, as confirmed in Van Breda, in South Africa, the price of living in a constitutional democracy as an accused person is that openness is the default and secrecy the exception. Therefore, the burden falls on the person who wants to shut out the media to bring the application to shut them out. So we submitted our request, our application, on the application form. It was granted. Now, if a party wants to have that permission taken away, they have to come on evidence, and not the evidence that comes spontaneously out of Mr. Tempo's mouth for 45 minutes. Evidence on affidavit that we can respond to, that we can rebut. Are the alterum partem? We have to be given an opportunity to rebut a factual case that we have done something illegal and deserve to be excluded. Those are our submissions.
I need a 10 minutes break to consider what has been submitted. We now 10 minutes to lunch time. Mr. Kotodali.
My Lordship, sorry to interrupt. I thought it was the court time again. If there's one issue the court really forgot to deal with it. We raised it in chambers. We submitted that. The documentary we're talking about, they staged the events of what happened on the day. That's a violation, what they did.
No, that has been indicated. I think I also raised it with him.
And furthermore, the reason why our documents are in this fashion, that's that we did highlight, is Act application number 1. We were responding to the state submissions. Hence, it's difficult for him to understand where we're coming from with this kind of Act application number 1, because they are not part of these proceedings. That's all, Your Worship.
Yeah. Can we adjourn? We adjourn 10 minutes before. Is it possible to be back here earlier? Like maybe 20 to 2? Madam, is that possible? Can we make it quarter to 2? I have to focus on a request. Some are calling it an application. And this request did not land on the court's table in the way an application should land on the table of a presiding officer. But I found myself in a catch-22 situation because it contained an issue which has to do with the quality of the proceedings we are busy with. The representative of accused number 1 to 4 presented via the registrar a document which was raising a concern about the presence of what we were referring to all along as a media house. There are several media houses involved in this case attending. I don't want to list them for fear of excluding some, because I wasn't given a full list of all media houses that are involved. The long and the short of the beginning of this matter is that media houses, many, if not all, applied or requested in written form by way of submitting forms in order to be able to be in attendance during the proceedings, and specifically to be inside the courtroom, and further particularly to be engaging in all activities that journalists are about in terms of recording and also observing all with a view to notify the public about what is happening within the concourse of this trial. The instructing attorney for the advocate of accused number 1 to 4 addressed court speaking to the document that was submitted, and in it there are issues that may be attended later, but when I spoke about catch-22, it was by dint of the fact that the issue raised is of a nature that can be left unattended at the risk of the correctness, if not purity, of the proceedings in this case. And for that reason, had the court gone the route of requiring a proper application while the case proceeds, what is feared and what was feared would have been going on or continuing whilst we await that process to end. That is why the court felt that it should attend to this request. Be that as it may, there has been a similar request before that had to do with a watching brief. The exception taken around the presence of the watching brief was not brought to the attention of the court through a formal application. We discussed this matter in chambers, and the court then made a ruling, which is what is going to happen in this matter, only with regard to the aspect of the participation of the people recording on behalf of Netflix. What Advocate therefore said is that there is an understanding, an agreement. I haven't seen that agreement written anywhere, but nobody challenged the fact that there is an agreement that the media houses shall be in attendance whilst this trial runs. And what is obvious is that there were no ground rules set. There are two reasons for the fact that there are no ground rules. The first is that it was presumed that the media houses that are at play are not attending court proceedings for the first time. It was assumed that they will know what to do and what not to do. It is not proving to be the case in this trial, in that the manner in which the cameras go to Zoom is somewhat questionable. What is normally the case is that the cameras concentrate on the people, the role players, in particular the witnesses, the legal representatives, and not and only when something is unfolding which is part of the proceedings. But in this case, for example, one of the legal representatives complained that even when they consult with their clients, the cameras go in and zoom, which is starting to diminish the comfort with which everyone is participating. The role players, in particular, even the accused, are being made to feel like sample insects in a bottle that are being watched, whose every move is being watched, and that goes for several other role players in this courtroom. The targeted entity, which is participating for the benefit of Netflix, indicated that they submitted a form like everyone else, and after submission of that form, they were granted permission to be in attendance. I think from their side, presumably to be doing all that they are doing, and all that everyone else from the media is doing, simply because no specific ground rules were put in place. And I'm going to come back to this point at a later stage, but shortly. The question of who is media house, who is something else, has not been brought before this court in a manner that can be verified. I, as presiding officer, I'm having to hear legal representatives rising up saying, this is not a media house, this is a media house. I'm also being told that there is an understanding. I don't know whether it's a rule, I don't know whether it's an outcome of any particular process that can be pointed, but there is an understanding that SABC shall be in attendance and shall lift everything there is to lift from a journalistic point of view, and whoever is interested in that will have to negotiate with SABC. Even that, I'm being told from the bar that there is that understanding. As to where it is grounded upon, I have not been appraised. What faces me is how to respond to the application. We are running a trial in an open court within a democratic dispensation under the auspices of the Constitution of our country, where public interest is recognized in our processes, and where the implements that satisfy the desires of public interest come generally recognized. And one of those implements, which is even more important, is the media, that they are at liberty to be in attendance like everyone else who is in attendance. It's just that the media get permitted to do even more, like taking pictures. Although I have noticed in this case that even people from the gallery are tending to take photos, and nobody does anything about it. My understanding was that that would not happen without specific arrangements for anybody in the gallery to be taking pictures. But in this case, I've seen that happen. Even this morning when I entered here, there were much photographs being shot even from the gallery, which I think is going to be more defined from now henceforth. Regarding the request, which I cannot describe as an application, like I said, it has to do with the purity of these proceedings. The first complaint, which even the state harped upon, has to do with a documentary which is said to have been flighted before the start of these proceedings. My view on that is that that activity, such an activity of flighting a documentary before the start of a trial, is not necessarily part of what we are here about. And I think somebody quite correctly mentioned that it should have been dealt with, and even now it should be dealt with outside the activities of this trial. If any law was undermined by it, and I would, from what I was told in court, there is possibility that some law or some consideration was undermined by it. The content of that documentary, I have not been privy of, because I was not looking around for any other things that are happening around this case, except what is coming through the evidence and the presentations of the legal representatives. But what I was told in chambers was that it hinges on issues that begin to apportion blame for the central issue, which is the death of Mr. Senzo Meyiwa. It begins to weigh up evidence and almost suggest an outcome, whatever the outcome is. My sense is that that should be viewed as very invasive, but it happened before the start of this trial. So I'm not going to concentrate much, except that I agree with the view that if anything happened along those lines which breaches or which goes to undermine the law, it is upon whoever is interested to take it up in a proper manner. Now, coming to the presence, having the history of, as explained, which I tried to verify with Mr. Weeks about the presence of the presence of his clients and what they are doing from a journalistic point of view. A fundamental point arises about, like I said in the beginning, who is who? Are they a media house? Are they something else? I think Advocate therefore indicated that in his observation, in his views, a very strong view, they are not a media house. And permission was granted to media houses for them to do what they are doing. As I sit here, all I have is information from the bar, from Advocate Tefo, that the people representing the interest of Netflix are not a media house. That is all I have. Beyond that, even the advocate for the state did not present me with anything that I can point to, that I can rely on to say this is not a media house. To complicate that further, whether they are a media house or not, they submitted an application. And in that application, they come across as one of the media houses. From what Advocate Tefo is saying, I'm left with cause to question what they are. But all I have is utterances from Advocate Tefo that they are not a media house, and they sit with a permission after filling that form. If that form was filled with untruth, it's a matter to be taken up by whoever is interested. In order to order anybody out, like it has happened before, I have to have reasons. I have to tell whoever. I have to say, Mr. Interpreter, please stay out of this courtroom because of reasons A, B, C, which I don't have as a fact. I don't have on my table. If the allegations are true that are being attributed to them, I think it will be ideal for people who conduct themselves in that way not to be inside this courtroom. But all I have is utterances by individuals. I think Advocate Baloy went some way in indicating, but a lot of what he has to say had to do with something that was flighted before the start of this trial. Although he then comes and links it with the issues of the purity of this trial. Advocate Tefo also went, I think, further in indicating that this misdemeanor on behalf of the people representing Netflix even goes outside the periphery of this courtroom, in that, like he said, they are stalking him. The issue of stalking is also not a matter for consideration for this court, except that I would be worried if I'm stalked. That's the furthest I would go in commenting about that. And indeed, one would not blame anybody who raises a concern about being stalked. But if that stalking did not happen within this courtroom and the courthouse, and did not coincide with days on which this case is running, I think I would be out of my periphery if I tried to address that and express on it. Now, coming back to the issue of the presence of the people acting on behalf of Netflix in these proceedings. Initially, I was very, very worried. I posed a straight question to Mr. The representative representing the interest of Netflix. I posed a straight question to say, will you say to me that you cannot rule out, Mr. Winks, that the possibility that your client may flight another documentary whilst this case is still running? And his straight answer to me was, nothing prevents them from doing that. He was later to capitulate on that and to say to me that he was answering a pointed question posed to him, and he has since taken instruction. And the instruction is to the effect that there is no intention to flight another documentary before the end of this trial, because a question was also raised as this debate was happening around possibilities of even witnesses being recalled, and therefore my fair assessment is that whatever we say should be about time when the case is still running, when before a verdict is given, and not simply about when certain evidence has been given by whoever. Having weighed up everything, my first comment before I give the ruling is that I don't have the wherewithal to order anybody out. I don't have evidence in place on the basis of which I can order anybody out. And I lack the confirmation, reliable confirmation about who is who. The people on behalf of Netflix applied as if they are a media house, and the permission was given on that basis. If they are not, as I sit here, I cannot say for sure. I know that they are not. I know that they were lying when they say they are a media house. And on the basis of what I have said, I cannot order the people representing Netflix to vacate the courtroom. I cannot order 10 films to vacate the courtroom. And I would imagine that whoever has an issue with that will take it up through the proper legal channels so that this matter can get a proper attention, because I don't think so far it has received proper attention. I have had to rely on people feeding information from the bar, and I would understand why it would have been possible, necessary to do that, because in the eyes of those people there is a wrong being perpetuated, and one would understand that one would not wait to go through the processes of coming up with a proper application. So my final ruling around is that the court is not ordering anybody out that applied to participate in this trial, especially those who applied on the basis that they form part and parcel of what is considered to be media houses. And I think that is my ruling.
My Lord, may I have the excuse? May I have the excuse, my Lord?
No, he's up. I don't know whether he's not on this issue.
My Lord, may I have the excuse?
I'm saying Advocate Tefo is up. I don't know whether it's on this issue. I can't be excusing you whilst he's addressing me.
We hereby accept the ruling of the court. However, we are intending to pursue it further outside this court. That's our intention of the case 124. That's the place I got. We just now want to proceed with the our ordinary course of these proceedings.
That being the case, you are now excused.
As it pleases my Lord.
And you are excused. Whilst you are excused, I'm relying on what you said. That you told me something from your head, then you got instructions, and we will not be seeing a documentary before we complete this trial.
Indeed, my Lord. Those are my instructions.
May I remind the witness that he is still under oath. May I also, I don't know whether to call it an apology. I recognize that you were made to sit here about what you are not here for, but that process had to unfold, and I know that you are not fully well. So on behalf of everybody, we apologize for the inconvenience. Advocate, therefore.
There's an emergency.
Oh, okay. Yeah, the other, you see, you speak in cross purposes because Advocate therefore keeps on saying we should deal with this witness.
No, we will cross-examine the witness.
Yeah.
I was referring to our reply to the state. There's other issues we raised them.
Yes.
I will wait to do them now or after we finish the witness.
No, that's exactly what I'm saying. I said, according to Advocate therefore we dispense with this witness first, and then I don't know whether you are of a different view, but that's what Advocate therefore has been saying all morning, that we deal with the witness and then we attend to this.
Maybe we can adjourn briefly. The court can just wait in the corridor.
Yeah, if nobody goes far, because Advocate therefore will be back in a jiffy, we need to use every available time for purposes of this trial. We shall have a short adjournment.
In relation to that one, Your Lordship, the question came about to the witness as for was he aware of the second case, 375 of January 2019? And the response was that I'm not aware. So it's also to remind him what he said from us, just to want to confirm that once we submit a certain document in a form of affidavit, considered to be affidavit deposed under oath by this witness, we are going to hand over, Your Lordship, such an affidavit to the court and the state as well as my learned colleague. This will be, is allegedly, affidavit deposed by the same witness in relation to Phosphorus Class 375 of 1/2019. As we follow the procedure in relation to the tradition of handing in the document, I hereby start with Advocate Barrow. This is for court. I don't have one from Sholola who will share. I also believe it will be a proper, Your Lordship, just to, I don't know if my learned colleague Victor will instead borrow the witness this affidavit, or should I give after the last copy?
Who lent the copy to the witness? Is it the state?
The state.
All right, okay.
So, thanks for the lawyer. Mr. Lola is also giving the benefit of a word. Everybody's got his in position on the document.
So this matter will be Exhibit D, if you can mark it as such. Yes, please.
Thank you.
Yes.
Yes, Mr. Mr. You want to go through first or you I can start?
You can start.
All right. Can the witness take a seat, Your Lordship, if he doesn't mind?
I think we seem to leave it up to him. We told him that sometimes he gets uncomfortable seated, sometimes he gets uncomfortable standing. So let's leave it up to him. You know, Mr. Sir, you know that you can sit and stand up or rise up when you feel like, because we know your state of health.
Yes.
Thank you. Mr. Mr. Can you go through Exhibit D? Can you have it Exhibit D in your position? Can you check, can you peruse this document and make inspection and tell this court if you are familiar with this Exhibit D?
Yes, I am familiar with the document.
You are telling the court that this is your affidavit. Do I hear you, sir?
That's correct, my lord.
Kuyiqiniswa-ke ukuthi iphepha leli eliphambi kwami ngiyalazi futhi-ke istatement esifungelwe esenziwa yimina.
When did you depose this affidavit? And under which circumstances?
There was a captain, it's a colonel who was from National Office, CSI.
kwakunokapteni noma-ke ucolonel owayebuya-ke kwa-CSI ehhovisi elikhulu noma e-national office.
And she introduced herself to me on the, I'm not sure of the date. I wrote it. Can I read what I wrote?
For sure.
On the 4th of June 2019, Colonel Butelezi from CS and CSM.
Are you reading paragraph 2?
Yes, so about it.
Why do you read paragraph 2? No, why? We need to assist
I wanted to answer.
We need to assist you to remind.
I wanted to answer direct your what were your question?
Oh, okay. When and the purpose.
You asked me about the date.
And the reason for deposing this affidavit.
I wanted to explain my reason for.
No, I'm not denying you. I say paragraph 2 to assist you to answer me.
That's correct.
Okay.
Inhloso yokuthi ngifunde-ke lo mcalo wesibili-ke ukuthi uzongilekelela nanjengoba ungibuze ngelanga kanye futhi nenhloso yokuthi kwakungani ukuze ngifikelele kwisinqumo sokuthi ngibhale isitatimende.
Continue.
On the 4th of June 2019, Colonel Butelezi from.
Can I interject? What date is that statement dated?
12th of June 2019.
Yes, let's proceed.
As a court, please, we don't want to interfere with it is the first of examination, but it's normal for the document to be proven first before you refer to it. Now, the witness is already going to refer to the contents without the document having been proved. Now, it's normal procedure towards the witness. Look at the document, identify the signature and the date, the language used, whether the witness agreed with the contents, etc., etc.
Advocate Tefo. Advocate Tefo.
Thank you, Lordship. Thank you, Principal Baloy. Your Lordship, I've done my introduction. I submitted to the witness. However, maybe the witness may have understood me in a different way. However, I will still just to continue in final handing over or submission procedural to him. Firstly, that's correct, let me take him through the whole document, like what was left before he confirmed to me. I think I just took it in summation, say he is accepted. Let's go to the last page, Mr. Msia. Despite that you have confirmed, can you check under the paragraph, the last paragraph, there's a signature there.
That's correct.
Is that your signature?
That's my signature.
Mina-ke owasayinda lelo phepha lokugcina.
And then there's a date stamp there. Can you see?
I can see my
What is the date?
12th of June 2019.
Istem sona-ke sichaza ilanga lange-12 kaJune 2019.
And there's a commissioner of oath stamp there. Can you see?
I can see that.
Do you see who commissioned this statement?
Yes, I can see that.
Do you know the person?
Yes, he is my colleague in Springs.
Kuyiqiniswa ukuthi sikhona nestamp esishoyo-ke ukuthi ngafungiswa noma esalo wayengifungisa uzakwethu ngisebenza naye eSprings.
Okay. When I go through this affidavit, okay, from the beginning there on top, can you read the top of the statement? Before your trouble journalism here, on top there.
That's not.
It's written there, by handwritten. Phosphorus,
Phosphorus S 375 of 1/2019.
Do you agree with this Post-adjournment case?
No, I was not aware of the case.
Lena-ke inamba ebhalwe la ewu-Force Laws 3751 2019 nangazi nayo.
Okay, let me say, who wrote that? Do you know?
I think it's the person I handed this affidavit to,
The police.
who's Colonel Butelezi.
Ngicabanga ukuthi-ke uyena uPenel Buthelezi lo enganikeza kuyena le statement owabhala lo Force Laws 3751 2019.
So what would this mean to you? If Colonel Butelezi can write Post-adjournment case as she written, what would mean this to you in relation to the purpose of the affidavit?
No, I'm not sure how to answer it.
Angazi-ke ukuthi ufisa ukuthi ngiphendule kanjani-ke uthi uma ngabe ungibuza ukuthi wayesho ukuthini-ke uPenel Buthelezi ngobhala lo 3751 ka-2019.
Okay, differently put, will I be correct to say, when you were deposing this affidavit, you were deposing this affidavit in relation to Post-adjournment case 375 of 29. Do you agree with me?
No, I was not aware. But the only case that I was aware of is that Post-adjournment case 636 of 10.
Okay.
636 of 10. 2014.
Ngangingazi-ke mina ukuthi yena-ke uPenel Buthelezi yena uma ngibhala le statement ungibhalisela i-case le ewu-375 ka-2019 mina enganginolwazi lwayo kwakuwu-Force Laws 636 10 2014.
Will I be wrong if I say, as you are here and giving testimony, you are giving the testimony in relation to case, Post-adjournment case 636 10 2014? Am I wrong to say that?
You're not wrong, that's correct.
Ikona-ke ngempela kunjalo ukuthi ukuba khona kwami la enkantolo ngizonikeza ubufakazi ngale ewu-636 10 2014.
And the investigating officer of course, Post-adjournment case 636 10 2014 is not Butelezi, it's someone else. Do you agree?
I'm not aware of the investigating officers involved in this case.
Okay.
Ukuthi webanike abaphenyi noma abaseshi balamacala-ke into engingayazi leyo.
That is an answer now. We talk about that. Let me assist you. So, I put it to you that when you were deposing this affidavit, you were deposing this affidavit in relation to the second case, which is the Post-adjournment 375 0129, for which investigating officer is Butelezi herself. Does it make sense? Now that it has been put to you.
It do make sense, my lord. On that day, when we met with the colonel, with Colonel Butelezi, she, after introducing herself to me, as she was coming from CS and CSM in Pretoria, regarding the matter under case 636, according to my understanding.
Ngalelanga-ke aweza ngalo kumina-ke yena uPenel Buthelezi eyichaza futhi-ke ukuthi ubuya kwa-CS kanye futhi no-CSM ePitoli weza-ke kumina-ke futhi-ke ngalecala leli kuthiwa
636.
leli lesibili eliwu-636 10 2014.
Now, on the basis of that answer, you now understand that there are two cases.
Now I understand.
Manje-ke sekuyangifikela noma sengiyazi-ke ukuthi unamacala amabili.
And then Butelezi is for 375.
That's correct. Now I understand.
Nokuthi futhi-ke leli eliwu-375 120 of 2019 lona-ke liphenywa uyena Buthelezi.
Thank you. Then let's go to this statement. Who wrote this statement?
I wrote this statement, my lord.
Umuntu owabhala istatement yimina.
This was handwritten.
It's my handwritten.
Isandla sami esasibhala la.
Can you read what you wrote?
Yes, I can.
Legibility. Can you see?
I can see, my lord.
But of course, some difficulties also. As long as you can read yourself. But your handwriting. But it's better than mine. Can you confirm the paragraph of this statement?
Yes, I can confirm.
How many?
Ten.
Unemita namake ama-paragraphs awu-10 kulesi statement.
10. Okay.
You said there were 10 what?
Paragraphs.
So, by the time when you were writing this statement, did you write this statement under duress, or it was out of your free will?
I wrote this statement after the Colonel Tilesi made a request for me, and the reason for that, for the statement, she explained.
No, just before you can go, carry on.
Yes, she explained the manner in which
No, before you can go. You are too much ahead of me. My question is, by the time when you wrote this statement, did you write this statement out of your free will, or you were like under duress? You were forced to
out of my free will.
Ukusibhala kwami-ke istatement ngasibhala kuyinto eyiphumela kumina-ke ngangingaphoqiwe.
Okay. And at that time, were you still active at work? Because I understand now you said you are on, what is that term? Incapacity. You were still active by that time.
That's correct, my lord.
Ngaleso sikhathi-ke ngangisesemsebenzini isikhathi sonke.
So did you tell us, say, write this statement? I understand you said, out of your freedom. Was she like sitting here and wait for the statement? Or she said, write the statement, at your own time, call me to come and fetch the statement? Was she like, write the statement? She was there at your work.
No.
I'll wait for the statement. Or she said, write the statement at your own time, maybe next week. Then call me, say, the statement is ready. Which one?
She collected the statement from me after some days.
After some days.
Emuva kokuthi angicela ukuthi ngisibhale wabuya-ke emuva kwamalanga wazosilanda.
So, what you are saying to this honorable court is that you had all times to think. 2019, January. By that time, the incident had happened 4 years, 4 months ago. Am I correct?
That's correct.
Kuyiqiniso-ke ukuthi ngalowo 2019 lowo ngenza lesi statement isehlakalo lesi sineminyaka emine ney'nyanga ezine senzeka.
So that means the Terezi afforded you opportunity to reminiscent everything that happened 4 years and 4 months ago. We didn't want to put pressure on you. And I think you did appreciate that.
That's correct, my lord.
Uyiqinisoko ukuthi yena-ke uKelvin Buthelezi wamnikeza-ke isikhathi sokuthi-ke ngicabange lokho kwenzeka kuleso sikhathi seminyaka emine eyendlula.
So everything that is written in this statement or affidavit is binding unto your conscience. Am I correct? Is binding unto your conscience. Everything that is written in.
That's correct.
Ngiqinisoko ukuthi futhi engibhalelana-ke into engaziyo-ke eyisibofezelo kumina ukuthi kuyiqiniso engakubhala.
You take the responsibility of everything that is here, the comma, the full stop, even the wrong spelling. Am I correct?
I'm not sure of the spelling, my lord.
No, in case there is a wrong spelling.
Correct.
Nami-ke ekhona lana ukuthi-ke khona ngibhale ngendlela engasiyona amakhoma nani nje ngizothi-ke ngiyakwamukela ukuthi-ke kuyimina.
So instead of saying Katle home, you say Ka home. You say that is a mistake. And I will accept it. Will I be correct?
That's correct.
Uma-ke ngingabhala-ke ngenza iphutha igama ngingabhali ngendlela efanele ngizokwamukela lokho.
There was a long delay this morning, Mr. Msia. We just didn't even start in a good footing. We've had the passing on of Major General Ndofu. May his soul rest in peace. Do you share the sentiment? Thank you, sir. Now let's start where we left. You remember when we were talking about the contamination of the scene of crime in that house. You know that house. You've been there. You were like, even if I can bring the TLB, the caterpillar, won't move you from your contention that the scene was never contaminated. You remember that was your vision. You cannot be moved. You cannot be persuaded that the scene there was contaminated. You will say no, insofar as you're concerned.
That's correct, my lord. I did not see any contamination.
Kuyiqinisoko ukuthi kathi ngifika-ke kwindawo yesehlakalo angizange ngiboneke ukuthi kwakukhona-ke ukuphazamiseka noma okwenzeka ukuphazamisana nayo indawo yesehlakalo.
It was you, Mr. Msia, you didn't see any contamination, and not only see contamination, not even suspect there might have been contamination. Am I correct? You are not even suspecting that. Not only see, you say you didn't see any contamination.
When I get
And I say, I further stretch your point insofar as your vision and your believers concerned. You did not even suspect that there was contamination of the scene.
on my arrival on the crime scene, I never suspected any contamination.
Kathi ngafika ngayo-ke angizange ngibe nazo ney'nsolo zokuthi kukhona okwenziwa ukuphazamisana naleyo ndawo yesehlakalo.
So you didn't see contamination, you didn't suspect contamination, you still stand there.
I never suspected contamination, madam.
Angikaze ngibe nazo iy'nsolo zokuthi kukhona okwenzeka khona laphaya.
Your Lordship, I want to request my honest witness here to go through this statement. Can you be able to read through this statement? Then I will take you on after you have gone through the statement.
I will.
This statement is long, Your Lordship. Can I sit down in the meantime?
Yes?
My Lord, I see it's about 10 to 3. We adjourn at 3. I wonder if it will be appropriate maybe this time to take the adjournment until tomorrow so that the witness can, in the meantime, also go through the statement. If it's in order with my learned friend.
I'm unable, Your Lordship.
I think the issue is when your clients have to be taken away from this courtroom.
That's correct.
That is the guiding factor.
This opportune moment at home, Mr. Messiah, you can go through. Thank you.
By agreement for further trial, this case is postponed with the accused in custody. It's postponed overnight to the 31st of May 2022.
Ala-ke kahle hlisa abafethu kuze kube kusasa ziyi-31 lenyanga esikuyona 2022 nisezohlala-ke ngaphakathi esitokisini kuze kube kusasa.
May I approve Focus 3, Your Lordship? Thanks for your indulgence, Your Lordship. There's a request from my client. They're asking if after the court, can they have 5 minutes? They are requesting 5 minutes with me. My client, after the court,
5 minutes with whom?
with me. My client.
Oh,
Yes.
Mr. Kotodali? They need 5 minutes after we adjourn.
So Susan, can I have your copy to make a copy? Of this statement? You're not going to use it tonight?